Hey guys, welcome back. Getting over being sick here. Kind of sucked. So the last video I was reading from the UCC Connection, and I'll, basically begin where I left off there. And if you remember, I was talking about UCC 1-308, reserving your rights, and UCC 1-103, argument and recourse. And it says here, if you want to understand this fully, go to a law library and photocopy these two sections, UCC 1-103, UCC 1-308. It is important to get the Anderson version. Some of the law libraries will only have the West Publishing version, which is very difficult to understand. In Anderson, it is broken down with decimals into 10 parts, and most importantly, it is written in plain English. This was written before the internet, okay? So section 23 here, recourse. Recourse appears in UCC at 103.6, which says the code is complementary to the common law, which remains in force, except where displaced by the code. That's why I don't use UCC. Why limit yourself to being in their jurisdiction or the rules that are under their jurisdiction? But anyway, you can still get remedy that way. A statute should be construed in harmony with the common law unless there is clear legislative intent to abrogate the common law. UCC 1-103.6. This is the argument to use in court. The code recognizes the common law. If it did not recognize the common law, the government would have to admit that the United States is bankrupt and completely owned by its creditors. But it is not expedient to admit this. The code was not written to entirely override the common law. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights pursuant to UCC 1-308, or if you just make an explicit, sufficient, and timely reservation of your rights, you don't even have to use the Uniform Commercial Code, then you can insist that the statutes be construed in harmony with the common law. If the charge is a traffic ticket, you may demand that the court produce the injured person who has filed a verifiable complaint. For example, if you were charged with failure to buckle your seatbelt, you may ask the court who was injured as a result of your failure to buckle up, quote unquote. However, if the judge won't listen to you and just moves ahead with the case, you will want to read to him the last sentence of UCC 1-103.6, which states that the code cannot be read to preclude a common law action. You can tell the judge, Your Honor, I can sue you under the common law for violating my rights under the UCC. I have a remedy under the UCC to reserve my rights under the common law. I have exercised my remedy, so you must construe this statute in harmony with the common law. To be in harmony with the common law, you must bring forth the damaged party. Note, actually, it is better to use a rubber stamp, because this demonstrates that you had previously reserved your rights. The simple fact that it takes several days or a week to order and get a stamp shows that you had reserved your rights prior to signing the document. Anderson Uniform Commercial Code Lawyers Cooperative Publishing Company. Okay. Yeah, get a stamp, great, but not a bad idea. If the judge insists on proceeding with the case, act confused and ask this question. Quote, let me see if I understand, Your Honor. Has this court made a legal determination that the sections of 1-308 and 1-103 of the UCC, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If the answer is yes, then you say, I put this court on notice. I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge will know this, so you have boxed him into a corner. Just so we can understand how this whole process works, let's look at a court situation such as a traffic violation. Assume you ran through a yellow light and a policeman gave you a traffic ticket. The first thing you want to say First thing you want to do is delay the action at least 3 weeks. This you can do by being pleasant and cooperative with the officer. Explain to him that you are very busy and ask if he could please set your court appearance for about 3 weeks away. At this point, we need to remember the government's trick. I'm from the government and I'm here to help you. So we want to use this approach with them. This is, this guy, I don't agree with doing this. You shouldn't even have to get a ticket if you know what to say, but okay. The next step is to go to the clerk of the traffic court and say, I believe it would be helpful if I talk to you because I want to save the government some money. This will get his attention. I'm going to appeal this case. As you know, in an appeal, I have to have a transcript, but the traffic court doesn't have a court reporter. It would be a waste of taxpayers' money to run me through this court and then have to give me a trial, de novo, new trial, in a court of record. I need a transcript for appealing, and to save the government some money, maybe you could schedule me to appear in a court of record. You can show the date on the ticket, and the clerk will usually agree that there is plenty of time to reschedule your trial for a court of record. Now, your first appearance is in a court of record and not in a traffic court where there is no record. Why would you consent to going into a court that's not a court of record? All courts are courts of record per the Constitution. Anyway, when you get into court, there will be a court reporter there who records every word the judge speaks. So that judge is much more careful in a court of record. You will be in a much better situation there than in traffic court. There is no record. The judge can say whatever he wants. He can call you all sorts of names and tell you that you have no rights and so on, and deny it later. When you get into court, the judge will read the charges, driving through a yellow light, or whatever this is, a violation of or ordinance, XYZ. He will then ask, do you understand the charges against you? Well, Your Honor, there is a question I would like to ask before I make a plea of innocent or guilty. Again, I would never make a plea. I would answer in the form of a demurrer. But anyway, I think it could be answered if I put the officer on the stand for a moment and ask him a few short questions. I don't see why not, the judge says. Let's swear in the officer and have him take the stand. Is this the instrument that you gave me? Handing him the traffic citation, handing the officer. Yes, this is a copy of it. The judge has the other part of it. And you would say, where did you get my address that you wrote on the citation? The officer, well, I got it from your driver's license. Number 4, above is very important to get into the record, clearly stating that you do not understand the charges. With that in the record, the court cannot move forward to judge the facts. This will be covered later on. Correct. If you don't understand, they can't go forward. There has to be understanding. That's their rules. You could literally say, I don't understand. I don't understand. I don't understand this language. I don't understand what you're saying. I don't understand. They can't go forward. They can try to belittle you. Well, you don't understand plain English? I don't understand. Anyway. Handing the officer your driver's license. Is this the document you copied my name and address from? Officer, yes, this is where I got it. While you've got that in your hand, would you read the signature that's on the license? The officer reads the signature. While you're there, would you read into the record what it says under the signature? Officer, it says, without prejudice, UCC 1-308. The judge says, let me see that license. He looks and turns to the officer. You didn't notice this printing under the signature on this license when you copied his name and address onto the ticket? Officer, oh no, I was just getting the address. I didn't look down there. Judge, you're not a very observant as an officer. Therefore, I'm afraid I cannot accept your testimony in regards to the facts of this case. This case is dismissed. In this case, the judge found a convenient way out. He could say that the officer was not observant enough to be a reliable witness. He did not want to admit the real nature of the jurisdiction of his court. Once it was in the record that you had written without prejudice UCC 1-308 on your license, the judge knew that he would have to admit A, that you have reserved your common law rights under the UCC, B, that you had done it sufficiently by writing without prejudice UCC 1-308 on your driver's license, C, that the statute would now have to be read in harmony with the common law, and the common law says that the statute exists, but there is no injured party. D, that since there is no injured party or complaining witness, the court has no jurisdiction under the common law. I'll see you soon. Thanks for watching.